This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, this is Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I'm very, very grateful. I've got an interview today with Sam Paredes from Gun Owners of California. If you are not aware of it, yesterday, I think, they had a victory in the Sixth Circuit Court of Appeals over the bump stock. We're going to talk about that in detail. There was also a court case that didn't go gun owners' ways in Hawaii with the Ninth Circuit, but I think that's actually a victory on its way to coming our direction, and Sam will expand upon that. Plus, there's some stuff going on in the federal courts, the legislature of the United States, and also the California legislature we'll talk about in this interview as well. But before we get to that, I do want to mention to you, if you'd like to support GunGuyTV, you can do that fairly easily. We have a whole lot of affiliate relationships with firearms-related companies like Caldwell, Tipton Cleaning, Wheeler Tools, Crimson Trace, Smith & Wesson Accessories, and a bunch more. And you can buy whatever you would normally buy from those companies. And in fact, Amazon is even in there. And so is Second Call Defense if you're looking for concealed carry and self-defense insurance. All of those things can be found at one link on our website at GunGuy.tv. I'll put that link in the description, but if you happen to be watching at a place where you can't get the description, just go to GunGuy.tv and look for the menu item about getting discounts on gear. It'll take you there. That way you can support GunGuyTV when you buy something and it won't cost you a dime. All right, let's get into the interview with Sam Paredes. Sam Paredes, thank you very much for coming on the show again, my friend. It's good to see you. We have a lot to talk about. I mean, we've got the Hawaii decision, which went against us. This is what it said in the news. The Ninth Circuit says the right to bear arms does not extend beyond your doorstep. Now, I've seen several headlines like that. Essentially, that's what they decided, isn't it?
Yes, it is. They took 150 or 200 pages to come up with this tortured logic that gutted and negated the Second Amendment to meet their political inclinations. It was amazing what they said in Young versus Hawaii, and everybody was worried, oh no, we're not going to be able to carry with our concealed weapons permit in other states that are in the Ninth Circuit. The fact of the matter is, as a result of this ruling, nothing has changed. The only thing they said in the ruling was that the laws of the state of Hawaii are valid, and as well as all the laws of all the other states are valid, and that the Second Amendment does not extend beyond our doorstep, that there is no right to bear arms. They use this amazingly tortured logic about long-standing laws that have been on the books for a long time, and that, you know, the courts should not be upsetting those long-standing laws. Well, if you and they cherry pick the issues that they want to use to justify their logic. But if you use the full extent of their logic, the Supreme Court of the United States would have never overturned Dred Scott, and we would still have slavery, because that was long-standing law in America before the Supreme Court finally said, oh, this is not right, and we need to overturn that ruling, because the Supreme Court ruled that slavery was legal. So using that, the type of thought process that the Ninth used to decide that the laws of Hawaii, which are totally unconstitutional, Mr. Young filed a lawsuit because Hawaii would not issue him a concealed weapons permit, and they banned open carry. So they, in essence, did not allow anybody to carry a firearm outside of the home, and so he lost in the district court in Hawaii, and then he appealed it to the Ninth Circuit. A 3-judge panel ruled that the laws of the state of Hawaii were totally unconstitutional and violated the core of the Second Amendment. And then the Chief Justice and several other appointed judges in the Ninth took umbrage to that ruling and granted an en banc hearing, which is 11 judges, including the Chief Justice, who is the arch anti-gunner on the court. And they reheard the case and came up with this ruling. It was argued last year sometime, and this case has been going on for several years. So, but the fact of the matter is, nothing changes in anywhere. Now, obviously, that is a case that we are going to appeal to the United States Supreme Court. There's no question about it. We cannot let that stand.
What do you feel the likelihood of the court taking that case might be?
I think that we are in a uniquely beneficial situation right now with the United States Supreme Court. Today, they had a conference meeting, and they were considering some cases either to grant certiorari, which means that they're going to accept it for hearing, or to pass for a while, or to not grant certiorari on some cases. Well, one of those cases is a case that was brought by the New York State Rifle and Pistol Association, charging that the state's concealed carry weapons permit laws are unconstitutional. And if they accept that case, they probably won't need to take Young versus Hawaii, because it is a substantially similar issue.
I want to just for clarification, the New York Rifle and Pistol Association versus New York case is not the same case that was found moot before. Would you explain the difference?
Sure. The first case, New York State Rifle and Pistol Association versus Grewal, was a case challenging the transportation laws of the state of New York. And if everybody remembers, the city of New York changed their laws. They got rid of the offensive laws. And then the court said, no, you can always change the laws back. So they got the state legislature to pass a law that said that the city of New York is forever banned from bringing that law back and putting it back on the books. So at that point, the judges of the Supreme Court said, well, okay, they have effectively, technically mooted the case because there is no longer a question because they changed the laws. Now, they could have still ruled on the case, but I think they wanted to have a clean case, and so they didn't do it. And this was before Justice Coney Barrett was put on the court, and there was some significant concern that the four good justices, four Second Amendment justices, could not count on, potentially Justice Roberts' vote on this thing. So they knew they were going to deal with this issue sometimes in the future, and with an additional pro-originalist constitutionalist on the court, I think that they're going to feel a little more easy about accepting the case and coming out with a good ruling. And, we have to thank the good Lord for having the justices that we have there that are thinking way ahead of time. They are so concerned about having a case that sets a wrong precedent that will be on the books for years to come, because they know how long it takes a case to make it all the way through the system to the Supreme Court. So I think they were looking out for the Constitution and the rights of law-abiding citizens by not accepting the cases. Some people have criticized the members of the court for doing that, but we knew that with patience we were going to have other cases, and with the addition of another justice solidifying a pro-Second Amendment majority on the court, that would be a good thing. And of course, the left is apoplectic about this, and this is one of the primary reasons that they're talking about packing the court. Passing laws to add more members of the court so that they can appoint anti-gun, Bill of Rights believing members to the court, and they will be able to stop the originalists from actually applying the Constitution of the United States to all citizens in the country. So that's kind of where we are.
The other big deal was yesterday, which was the Sixth Circuit. And GOA had a pretty profound victory there, but I think it goes beyond. I mean, just to give you the news story here real quick, and since I did that before, this is the kind of headline you're going to see here. Bump stocks are not machine guns, Sixth Circuit rules. When I read this case, and I don't want to get too far in the weeds here, but I think you'll be able to explain it better than I. When I read this case, what struck me is that it was less of a firearms case and more of a reining in of regulatory agencies making rules just as bureaucrats and establishing crimes that have criminal punishments. Have I read that incorrectly?
No, you are absolutely correct. And that is a major victory for our side. What Chevron deference is that when the Congress, the legislative body of the national government, passes a law and the terminology that is used is a little bit ambiguous or not really clear, Chevron deference says that the implementing agencies have some latitude in defining what that terminology is. But the smackdown that came from the 6th on the ATF said that, hey, guys and gals, Chevron deference does not extend to laws, to the criminal laws of the federal government. So it has never extended to those types of laws, and it's not going to extend to those types of laws now. That if the legislature wants to define a machine gun as something other than what is in the books and what the ATF has been explaining to people for decades, it is the legislature's prerogative to do it. But with regards to a firearms law, the ATF cannot define what a machine gun is beyond the letter of the words of the implementing statute. That is huge. Now, there's a lot of controversy amongst the gun groups whether, bump stocks are a big deal, and some people like them, some people don't, some people find them as fun. Some people say, oh, that's the kind of thing that kind of causes injury to our side and all that stuff. All that being said, and that's a controversy that is within the confines of the gun community pretty much. But the fact that they said that the federal government, particularly the ATF, cannot, on their own whim, change the definition of the terminology used in the statutes is huge, because the logical extension of that is that they could change the definition of a handgun. What constitutes a handgun and what isn't. They can redefine that, or a long gun, a shotgun, or a semi-automatic, or whatever. If they can do it with this, they can do it with all manner of things. And this ruling prevents it. Now, I have to be totally clear. That doesn't mean that bump stocks are legal for the states within the 6th Circuit Court of Appeals. What it says is that the court remanded it back down to the lower courts for them to seriously consider the injunction that Gun Owners of America and Gun Owners Foundation and several other pro-gun organizations were requesting of the court to issue an injunction against the application of the ban on bump stocks. And the court said, no, you don't have any, no, we're not going to do that. And then went to, it was appealed to the circuit court. So we still have to wait. As of right now, they are still illegal. And now the lower court, the district court has to, they've taken away the argument of Chevron defense. And without the argument of Chevron defense, and they have to use the meaning of the words, we're pretty confident that they're going to have to issue an injunction and say that in the 6th appellate district, it is illegal for any state to ban bump stocks.
So this case is really key. I mean, the other day, Sam, I interviewed Dan O'Kelly, from gunlearn.com. Dan is a retired ATF agent, comes on the show periodically. And I asked him specifically about why it is that the ATF gets away with this kind of stuff repeatedly. And he answered that question. Let me show you the clip. I'm dumbfounded as to how a law enforcement agency can continue to violate the constitutional rights of Americans under the guise of enforcing laws that aren't laws and enforcing regulations that aren't regulations against items that are not illegal and somehow face absolutely, or appear to face absolutely no repercussions and absolutely no consequences for having done that. How is that even possible?
There's no oversight. When ATF does something like this and then they're found to be wrong or knowingly wrong, even worse, who is it that's going to sanction them? Who's going to do anything to them? Who can? There is no oversight. There's no repercussion.
So, I mean, the basics of his answer is there's no oversight. And when they do this stuff, who's going to hold them accountable? Who's going to do it? No, there's nobody to do it. Well, I think we've just discovered that at least in one case in the Sixth Circuit, the federal court is tired of this, and they're going to hold them accountable. So I think this applies. Does this not apply if this type of behavior on the court's part goes forward, where they start holding regulatory agencies to task and taking them to task over this stuff? That applies over a wide range of things. It's not just gun issues, and it's not just ATF. It's just about everything, isn't it?
Yeah, pretty much everything that has to do with criminal law and anything that has a criminal penalty to that. As you mentioned, they've used Chevron deference on all manner of issues that are not necessarily constitutional questions. So in this case, the fact that all of the gun laws, violation of all the gun laws have a criminal penalty, and so those are off the table, and it'll be the same thing probably for all other laws that have to do with crimes and that kind of stuff. So yeah, you're right. And the only oversight they got, and everybody will remember, it's no secret that the Trump administration was pressuring the BATF to do something about bump stocks, and this was the solution they came up with. So that they bowed to political pressure on this issue and came up with this. They thought they could get away with this, and they kind of mangled the precedents of SCOTUS and came up with this change in the regulations by redefining the term of what a machine gun is, and they didn't have the ability to do that. So this is going to be very helpful.
And there's some stuff going on in California, I know. What else should we be talking about that we haven't talked about already?
This is one that particularly distresses me. They've got a bill, and I will come up here with the bill number. But what it says is that if this law passes, law enforcement agencies are to conduct an investigation of all of its officers and all candidates to become officers with their agencies. And if they have any association with so-called hate groups, they are disqualified from serving as members of the police or the deputies or highway patrol or anything like that. And the issue is they get to decide what a hate group is. Now, me personally and my colleagues here from NRA and CRPA, we have been before the state legislature and on the dais, and we've been called murderers, baby killers, heartless, bloodthirsty, all of these things. So to me, that sounds like they're setting the stage to call gun owners in California and other organizations a hate group because we support the right to keep and bear arms. And it is a totally political question that they use to decide what a hate group is.
A very large percentage of law enforcement officers in the state of California are pro-Second Amendment. And many of them are members of CRPA, Gun Owners of California, Gun Owners of America, and NRA, and so on. Mm-hmm. They're going to end up wiping out about half the police department or better if they apply that type of a barometer to who gets to serve and who doesn't, and they include pro-Second Amendment groups as hate groups, which I must admit I wouldn't be surprised if they did. Yeah. Are there any other
yes.
of the collection you've got that's about this high? Are there any other specific bills that you think we should
there's
urgently?
Another bill
Go ahead.
There's another bill directed at law enforcement, and what it says is that all law enforcement guns, duty and private, as of 2023 was amended last Friday, a bill amended last Friday, and you can go and get all the information on our website. And it says that law enforcement will have to have all of their guns microstamped. Now, so far, they haven't been able to force law-abiding citizens, non-LEO citizens, residents of California, to get microstamping. But they're saying that for any gun that a law enforcement officer has, owns, possesses, uses, it has to be microstamped. Now, the author plainly stated what his intent is. They want to force manufacturers to use the technology. It doesn't matter that the manufacturers have proven that the technology is nowhere near ready for prime time, that it is unreliable, inconsistent, and will cause so many legal issues that the liability that a manufacturer will undertake if they start microstamping their guns is immense. And they could be sued out of existence if they make one mistake with mismatching a firing pin and a receiver serial number. There's another bill that goes after gun shows again. They want to ban gun shows on state-owned and now county-owned property. They want to make that illegal, and they just don't get the message that the courts have basically ruled that you cannot ban a legal activity from occurring on public property.
I want you to answer a question for me, because every time I do an interview, somebody, I shouldn't say that. There's going to be a time I do when they don't post this, but most of the time there are always the question, why isn't somebody suing about this stuff? Well, obviously, GOA just won a big victory in the Sixth Circuit Court of Appeals. It's not because they weren't suing about this stuff. It's because they've spent, it cost hundreds of thousands of dollars to get it to that point in the first place. So what are we suing on at this point in the state of California?
There are lawsuits either in state or federal courts on microstamping, on the roster of safe handguns, on assault weapons, on concealed carry, on magazines, on ammunition. There are lawsuits against everything making their way through the system. And frankly, lawsuits cost a lot of money, and we have to use the resources that we receive wisely in order to file amicus briefs and support the lawsuits that are we want to support all of them, and we try to support all of them by drafting friend of the court briefs that support the lawsuit and bring the arguments that we want to address, besides the main arguments that were filed by the plaintiffs. So there are lawsuits on everything. And most importantly, this is not only a strategic, but a tactical thing. We are waiting with great anticipation for the court to give us a ruling. And on every case that they are going to accept and hear, potentially, we are addressing the core issue of the lawsuit. But the big thing that we are doing in our court briefs is asking the court to please say enough is enough and direct the lower courts to do as Justice Scalia said in Heller versus Washington, D.C., that they are not allowed to use judicial two-step balancing tests with regards to any Second Amendment case, that the only thing they can use, the only standard that exists legally, is the text, history, and tradition of the meaning of the words at the founding. So what did right to keep and bear arms and not be infringed mean when they signed the Bill of Rights?
I think there are, as you said, an awful lot of positives there, one of which, it seems to me, has got to be the number of new gun owners in the country. I keep bringing that up. I mean, there are millions of them here in California, but there are many, many millions. I've heard figures of 8 million, 20 million, and they've been bandied around like that. How do you, I mean, of all, and I should say of all political, across the political spectrum, how do you feel that affects, does that have an effect, and if so, how, on the legislative priorities of the United States Congress, for example, or the legislatures in the states? Does that have any effect on them at all?
Absolutely, it does. They are apoplectic here in the capital in Sacramento, and we know that the anti-gun hard left in the Congress is just going crazy because 8 million new people bought guns for the first time throughout the fruited plain. And, they're saying somewhere between 600,000 and 1 million people here in California bought guns for the first time. And it's because, and we're getting this by talking with dealers, and 100% of the dealers tell us that the people who were anti-gun, many of them anti-gun, many of them of all the political spectrum. And they say, after watching what happened to this country with the pandemic and the riots, we came to the conclusion that we have to be our only first line of defense, that when you need a police officer now, they're 15 minutes away. And so when people saw people rioting in neighborhoods and in communities, they said, I can't let that happen in my family. And then when they came to the gun stores, especially here in California, and they found out, what do you mean I have to wait a 10-day waiting period? What do you mean I have to have a background check? Don't they know who I am? What do you mean I have to take a test to show that I am proficient in the loading and unloading and care of the firearm that I'm going to purchase with a firearm safety certificate, and that I understand what the safety rules are? What do you mean? I thought none of this stuff existed. We've been told that we've got the gun show loophole and universal background loophole and all of these other things. I didn't realize, and they're coming to the realization that they have been sold a massive bill of goods.
We think about new gun owners going out and buying a handgun, and a lot of them do, but there have been an awful lot of ARs, AKs, and other what folks are now calling modern sporting rifles going out the door as well.
Yes.
And some for self-defense purposes and some for hunting, because hunting has the involvement of new hunters is off the charts as well. And so when Congress, in particular, when Dianne Feinstein comes out with Mr. and Mrs. America, turn them all in, I want to come get your AR again, with the brand new assault weapons ban and trying to reinstitute that, and the current resident of the White House decides she wants to do the same thing, it appears to be going nowhere in the United States Congress. And I would ask you to briefly comment as to why you think that is.
In the Congress, even though it's a very close margin, there are more Democrats than there are Republicans. There are a significant number of Democrats who, the blue party people, who represent districts that are red. And they know that if they vote against Second Amendment rights, they will not be reelected next year. In the Senate, as long as the filibuster remains in place, they know that they couldn't pass an anti-gun Mother's Day resolution and have it sent to the president's desk, because there are enough pro-gun Democrats, just a handful of them, and the vast majority of the Republicans who have voted to protect the Second Amendment, and they will not be able to get anything passed on the books. They see the same statistics that you and I are seeing, Joel. They see the same stuff coming out from the FBI and the Department of Justice and the various states, and they, I think, are coming to the conclusion is, oh my gosh, we've created a monster, and we better not poke that monster, because it may come back to bite us politically. And politicians' goal is to get reelected.
Well, Sam, thank you very much for coming on the show again. It's just a joy to spend some time with you.
Always a pleasure, Joel. We always cover very important information that your listeners and our members and friends and supporters need to know. And we want to dispel every myth that is out there. If we need to be running for the hills, we want it to be the truth, and we will be the first ones to tell you. But right now, we are not anywhere near that. We are in a good fighting position, and with continued support, we will win, and we will restore and then protect the Second Amendment for our children and grandchildren.
Thank you again very much for listening to the interview and getting the information we want to pass on to you. And frankly, for all of your support of GunGuy TV and of me. I'm very, very grateful. Wherever you go, whatever you do, stay safe.